Welcome to the InfoBrokerWorld podcast, where business intelligence meets global strategy, empowering entrepreneurs with the insights they need to stay ahead.
In today's highly competitive and dynamic commercial landscape, the comprehensive safeguarding of brand assets must extend beyond formal registration. It includes continuous monitoring of unregistered or so-called common law trademarks. These marks, while not recorded in public registries, often carry enforceable legal rights, particularly in jurisdictions like the United States that adhere to the first-to-use principle. In such environments, an unregistered mark, if used continuously in commerce, may enjoy priority over later filed registered marks within its established geographic and commercial scope. This presents a significant risk. A business may inadvertently infringe upon a prior unregistered mark without being aware of its existence, potentially leading to costly legal disputes or enforced rebranding. Unlike registered trademarks, which are accessible through centralized databases maintained by national or international trademark offices, common law trademarks are inherently more difficult to monitor. They do not appear in official search systems such as the USPTO database, the EUIPO's TMView, or the WIPO's Madrid Monitor. This lack of centralization requires companies to adopt a more holistic, proactive, and technologically advanced strategy to identify and manage risk. Effective monitoring of common law trademarks begins with digital surveillance. Search engines remain an essential but often underestimated tool. Regular keyword monitoring across search results, blogs, news outlets, and e-commerce platforms can reveal unauthorized uses of identical or confusingly similar brand names. Similarly, active surveillance of major social media platforms such as LinkedIn, Instagram, Facebook, and X, formerly Twitter, is vital. These platforms often serve as first points of brand expression for startups and small businesses. Furthermore, marketplaces like Amazon, Alibaba, and eBay must be systematically checked for infringing listings, including counterfeit products and misleading branding. Domain name monitoring is another critical component. The registration of domains that closely resemble a brand, either through typographical variants or alternative extensions, can pose a threat to brand integrity and consumer trust. This practice, often referred to as cybersquatting or typosquatting, can be detected and addressed through specialized monitoring services. The scope of monitoring also extends into copyright. Companies must protect digital assets such as website content, visual designs, product descriptions, and marketing copy. Utilizing access controls and encryption mechanisms is increasingly important to prevent unauthorized replication or misuse of proprietary materials. Given the complexity and scale of monitoring in the digital economy, the use of professional services and artificial intelligence has become essential. Providers such as Corsearch, Points Dennemeyer offer automated surveillance across trademark registries, domain databases, and online platforms. These systems utilize advanced technologies including machine learning, image recognition, and natural language processing to identify not only exact matches, but also visual approximations, phonetic similarities, and even culturally specific naming patterns. These AI-driven platforms offer additional advantages by collecting evidence of infringement, such as screenshots, timestamps, and URLs, all of which can be compiled into legally admissible documentation. More advanced systems can also forecast potential conflicts based on market patterns and historical infringement behavior. Nonetheless, despite the sophistication of these technologies, human expertise remains essential. Trademark attorneys must interpret findings, evaluate the likelihood of confusion, and advise on the appropriate legal response. Upon identifying a potential infringement, brand owners have several options at their disposal. In many cases, a direct and non-confrontational communication with the infringing party may be sufficient to resolve the issue. In other situations, a cease-and-desist letter, ideally drafted by legal counsel, may be necessary to assert rights formally and preempt potential counterclaims. Where the parties are not direct competitors, a coexistence agreement or licensing arrangement may offer a pragmatic and mutually beneficial resolution. In cases involving registered trademarks, opposition or cancellation proceedings may be initiated through the relevant intellectual property office. For instance, at the EU IPO or DPMA, trademark owners have limited windows, typically 3 months from publication, to oppose conflicting applications. In Germany, cancellation actions for non-use or bad faith can now be pursued directly before the DPMA, a more cost-effective and expedient route compared to civil litigation. In more severe or high-stakes conflicts, litigation remains an option, though it is typically reserved for scenarios where other avenues have been exhausted or where the infringement is particularly damaging to brand value or market position. Investing in a robust common law trademark monitoring strategy offers numerous strategic advantages. Chief among these is early detection. Identifying conflicts before they escalate enables faster and more cost-effective resolutions. Monitoring also plays a preventive role by deterring potential infringers who recognize that the brand owner is actively policing its rights. Moreover, consistent vigilance safeguards a brand's integrity. When left unchecked, unauthorized use can erode the distinctiveness of a mark, a process known as dilution, and expose consumers to confusion, counterfeit goods, and reputational harm. From a financial perspective, proactive monitoring significantly reduces legal risk, supports brand valuation, and ensures continuity in marketing and commercial strategy. In addition, the intelligence gathered through monitoring provides valuable insights into competitor behavior, new market entrants, and shifting trends. These data points can guide decision-making in areas such as product development, expansion strategies, and strategic partnerships. Finally, a history of documented monitoring and enforcement demonstrates the seriousness with which a company protects its intellectual property. This can prove decisive in legal proceedings and is a strong defense against challenges based on delay or inaction, such as the doctrine of laches. In conclusion, monitoring common law trademarks is not a supplementary measure. It is a core element of any credible brand protection strategy. In an environment shaped by rapid digital transformation and global competition, only those brands that combine technology, legal expertise, and strategic foresight will sustain their distinctiveness and long-term commercial value.
Thank you for listening to the InfoBrokerWorld podcast. If you have any questions about today's topic, feel free to reach out via the contact details in the show notes. This podcast was created using AI tools. If you're interested in producing your own AI-driven podcast, from concept to audio, feel free to get in touch. We'd love to hear from you. Until next time, stay informed and stay ahead.